Good afternoon again, everyone. Thank you for being here. I would like to welcome you to our webinar on Behind Closed Doors, Domestic Violence and Your Parenting Rights, which is hosted by MedTrack Action on Violence with our guest speaker, family law lawyer, Athena Narsingh Barnett. My name is Andrea Collins Fitzpatrick, and I'm the legal director with MedTrack. I would like to begin this afternoon with a land acknowledgement. We acknowledge that many of us are located in different places, but we will recognize the territory on which MedTrack is located. So we acknowledge that this land is the traditional territory of many nations, including the Huron-Wendat, Haudenosaunee, and the Mississaugas of the Credit. Today, the meeting place of Toronto is still home to many Indigenous people. We honor all the First Nation, Métis, and Inuit people living on this land. We recognize the traditional territories on which our organization is located and on which our programs and trainings take place. I would like to remind you that this webinar is for general information purposes only, and it is not legal advice. Legal information provided is not intended to be used as legal advice for a specific legal problem. I would like to note that we may be discussing sensitive content and that this is a safe space, so we please ask you to exercise self-care. This webinar is being recorded and reflects developments in the law before today, September 24th, 2025. It will be posted on our website at onefamilylaw.ca, that's onefamilylaw.ca, along with a copy of the PowerPoint slides. Please post your questions for Athena by using the Q&A function at the bottom of the screen. Before I move to our presenter today, I would like to tell you a bit about MedTrack. Many of you may know MedTrack works to end gender-based violence across communities through education, research, and policies. We have been in existence since 1984, and our programs are devoted to advancing safety, justice, and equity. MedTrack's Community Justice Program provides legal, education, and information related to gender-based violence. Through our Access to Justice program, we provide legal information in areas of family law, immigration law, criminal law, employment law, and human rights law. This webinar is part of our Family Law Education for Women, FLEW, F-L-E-W series. FLEW's resources are available in 14 languages, ASL videos, and accessible formats. You can visit our website at onefamilylaw.ca, that's onefamilylaw.ca, for more information on your family law matters. I'm excited today to have Athena Narsingh Barnett to speak to us about domestic violence and your parenting rights, and I thank you again for joining us today. Before I introduce our presenter, Athena, I would also like to thank our team, Fiz Malik, our project lawyer, Fatoumata Kamara, our coordinator, Kenny Ann, program manager, and our technician, Ferdinand Wilhelm. So I'd now like to introduce our presenter, Athena. Athena Narsingh Barnett is a lawyer who has been practicing family law for 8 years in the Greater Toronto area, doing family law litigation. She previously worked at the Malvern Family Resource Centre, working with newcomers and survivors of domestic violence. Athena has also worked at the Immigration and Refugee Board, Canada Border Services Agency, and the Service Canada. We are thrilled that she's presenting today and that she's taken time from her busy schedule to do that for us. Please enjoy the presentation, and I'll now pass things over to Athena. Thank you.
Thank you so much for the introduction, Andrea, and thank you guys all for being here today. So what my topic today is talking about what happens when you have an incident of domestic violence to the legal process, both criminal and family, and how they intertwine. Today, when I'm going to be discussing this topic, I will use the example for my case law, or my case, as a husband and wife situation with children involved. In the examples I'm going to give you throughout, the husband will be the person abusing, and the wife will be the domestic violence victim. And that's just the term that I will be using today, but I appreciate that there are other terms. I also appreciate that in domestic violence situations, anyone can be the abuser and anyone can be a survivor. And it also could happen in same-sex relationships, but this is just the example that I'm using today. So what happens in a situation when you are facing domestic violence? So in the example I'm going to give, this is not where your life is immediately being threatened. This is a situation where I commonly see in family law, where someone's being physically abused constantly, and then there's one final event that leads up to where the police are involved. That's the main aspect of domestic violence I'll be focusing on today. And then I'll be discussing the criminal charges, the family law process, and how to navigate the parenting after that. So first, I'll start off with domestic violence as is defined in the Divorce Act and the Children's Law Reform Act. So in family law, there are two courts and two jurisdictions that will actually govern your situation. So Divorce Act is for anyone that's married and or owns property. That'll be governed by the Superior Court of Justice as well as the Divorce Act, and that's the legislation. The Children's Law Reform Act also applies there. If you are not married, you'll be going through the Ontario Court of Justice, and that's with the Children's Law Reform Act is the legislation that's going to be governing that. Family violence is defined in both aspects. So what I'll discuss is the behavior of a family member that's violent or threatening, controlling or coercive. It causes someone to fear for their safety or the safety of another person, and it exposes a child to any type of this behavior described. So a child can be involved in the domestic violence either directly or indirectly. Directly meaning they were physically harmed, or indirectly meaning that they were a witness to it. Family violence can be physical abuse, it can be forced confinement, sexual abuse, threats of harm, failure to provide the necessities of life, psychological abuse, financial, threats to kill or harm either animal or property, or killing of animal or property. It doesn't have to be a criminal offense in order to be seen as family violence. So if the person that's the abuser, in the case that I'm using, if the husband is abusing, then it just because he doesn't get charged by the criminal court process, it doesn't mean it's not family violence. And again, the definition includes psychological, financial, but in the examples I'll be giving you for our case, it's going to be physical abuse. Family violence, like I mentioned before, it can be indirect or direct, especially when it comes to a child. If the child hears it or sees it, that's also indirect exposure. Now, with respect to the definition of a family member, in the Divorce Act, again, that's in the Superior Court of Justice if you're married, it's defined as a member of the household of a child of marriage or spouse, as well as a dating partner. So that's in the situation if you're married, dating partner, but that's the definition on the Divorce Act. Children's Law Reform Act, which will be applicable to the Ontario Court of Justice, it includes a member of a household of a child or a parent, as well as a dating partner within that household. So the main focus on the definition is just someone within the household. Immediate safety and legal response. So here's my take on this part of it. I tell people that if you are facing physical abuse or financial or any kind of psychological abuse, document your incidents, whether it be on a notepad or a phone. I will say that some people fear that their partner is going to find their phone or their notebook to see all the incidents being reported or recorded. It's up to you to decide what's safest for you and what you're most comfortable with. When you document your incidents each time to the best of your ability, you're going to write down who was present, whether the children were there or not, whether it was physical abuse, psychological, financial, and you don't necessarily have to categorize it, but at least document the details as much as possible. And a lot of people do this because they're not quite ready to contact the police or separate from their spouse. So they just keep a record of everything because it can be used later on. In a situation where the example I'm going to give is someone was abused physically several times, and this is like the icing on the cake, the last straw, they've decided to call the police, it's up to you to evaluate whether or not you want the police involved. Are you in danger? Is the danger immediate? Do you feel like this is the final call for you and you need to contact the police? You can do so. If the abuse is physical, of course, find a safe space immediately if you can. A neighbor, a local store. But again, this is not the specific case I'll be focusing on, but it is important for you to evaluate your safety or the safety of the person that's involved. So deciding if you should bring the children along. In the situation where it's life-threatening, that is a situation where you decide to bring the children along. But the case I'm thinking of where it's a physical abuse that's happened and you're deciding if you should bring the children, you're going to want to evaluate if you can bring them. If you decide to go to a family member's house or a friend or a shelter, is it possible to bring the kids there? Will the family members allow them to come? Are you able to care for them? Do you work shift work? And I know some people might say, oh, it's like physical abuse. You should always bring the kids. But that's not always the case. It's not always practical. And it's up to you to decide what's best for you and for the children. I will talk about whether or not you bring them and the implications of that. So what happens when you do call the police? If you call the police and you're both still in the same household, or you've just relocated down the street, or in this case, the husband has just gone down the street and you're separated physically, then the police will attend the house. Whether or not they come immediately, it depends on your area. I've seen situations where the police come 3-4 hours later. I've seen the situation where the police come right away. So the police will come. And they will separate you and the partner, and then they'll ask questions. So they might apprehend the domestic partner, but they will separate each person, ask them questions about the incidents that happen, and they'll decide whether or not they want to charge. In the case of example I'm giving you is the husband. So if the husband's charged with assault or another charge, they are going to either be arrested and taken to jail, or they might be released on their own recognizance, what it's called, or they might just say, hey, you can go, just go to another house, or the wife might say, go to another house, I'll go to another house, and then that way they're physically not together. The bail conditions, they'll be given bail conditions, and it'll outline the parenting restrictions, if any. So if the child was harmed physically, the bail conditions will prohibit the husband, in the example, from taking the child for parenting time. If the child was just present, it's up to the officer. They may say there's no parenting restrictions, but parenting can't be coordinated from husband and wife. It has to be through a court order, a family lawyer, or a third party. What happens if you want to change the bail conditions? So if the wife says, hey, I do want to change the bail conditions because we don't have a family member to coordinate pick up and drop off, or I can't afford a family lawyer, or the court process is going to take too long, they would have to contact victim services to see if that's an option, and they'd write a letter to victim services to say that they would like to change the bail conditions, and then the husband would also make an application to the court to change the bail conditions. Now, what's the practicality of it? If the husband and wife are separated physically and there are bail conditions in place outlining, okay, you can't see the children at this time, or a third party has to facilitate the parenting time, how's that going to actually work? So a lot of people, they will go through lawyers, a family lawyer, but to retain the family lawyer sometimes might be too expensive, or it just takes too long to do that. Oftentimes a third party, so like a grandparent or a family friend, will help coordinate. So they'll coordinate the pickup and drop off time, and they will physically pick up the child from the wife and then drop the child to the husband. Now, what happens if you leave the children with the other parent? So if you leave the child, so if the wife leaves the child with the husband, then the wife is going to have to coordinate the parenting time, as well as that it aligns with the bail conditions. So if the husband has the kids full time, the wife will have to say, okay, I'll pick up the children at this time, or my third party will pick up the child at this time and drop the child back off. So it's going to be the other way around. Which is fine. It's just depending on what works in the circumstances. Now, navigating the actual court system, the legal process, and co-parenting. So the criminal process is going to run alongside the family process. It doesn't go one after the other. It's just going to run alongside. And there will be aspects of it that will intertwine, and more specifically, bail conditions, or if charges were dropped, that's going to play more of a role. So in the situation where the criminal process, as we talked about, the incident that happens, calling 911, the arrest that happens potentially. After that is a court appearance. So the court appearance, there may be several of them, and this domestic violence cases in the criminal process average about a year, if not more. So what will happen at the court appearance is the prosecutor may ask for a meeting beforehand, so it's called a Crown pretrial, and they might go over all the disclosure that's going to be provided. So the officer is supposed to provide disclosure, or the court will, and the disclosure outlines the evidence, whether you submitted pictures to the police officer, whether you wrote a letter or you gave a statement to the police officer, or you signed a physical statement, and the husband will actually get all of that documentation. And then the Crown, which is the prosecutor or the government's lawyer, will say, hey, I think we should go ahead and charge this person. I want to do a trial, or can we negotiate a deal? So oftentimes in the criminal process, particularly in Toronto, you'll get a lot of people, or in this case, the husband, who will get an offer to say, can you do an anger management course? And then we'll drop your charge. And a lot of people do that. Most people don't get to the trial stage. If the trial stage does happen, then the wife will be called as a witness, and any sort of documentation that's being provided. So the document of incidents would play a role. Any sort of, again, pictures, evidence, or any statements will also play a role. And then the wife will have to go on as a witness in a trial to give her testimony on what happened. Whether or not that actually gets pursued or the husband goes to jail will depend on what happens in the actual situation. Alongside this, you'll also see the family court process. And I will say it is very stressful to go through any of this. So if it's very normal for anyone to feel overwhelmed. So there are resources that we'll go through later to see if you need any sort of assistance or anyone needs assistance. In the family court process, so we have an application or an urgent motion. These are two different options. The application is bringing a court document to get a court case, and you're writing out what you want. So if you want parenting time, if you want sole custody, which is now called decision making, if you want to travel with the children, if you want the other person to not have parenting time, this is what is in your application. So you're starting a court case in family law with these forms. Then the other person, so the husband has 30 days to respond. And then after that, you'll get a first appearance. So there is a document in between, but I've skipped it over because it's not common. But you'll get a first appearance or a case conference. Now, at a first appearance, it's just with a court clerk, and they're just going to make sure all the documents are in place and schedule a court date. The case conference is where the judge will give his or her opinion on what they think should happen. So the judge is going to say, I understand there was violence and the child was present. What I would suggest is that the husband get parenting time with a supervised visit. So the husband's parenting time may be Saturday and Sunday. It might be at an access center. In the access center, for those of you who don't know, it's like a YMCA or an organization that literally watches the parenting interaction between, in this case, the husband and the child, to make sure that everything's okay, and they'll take notes. So their notes will be used in the court process to say, yes, this dad is fine. He can safely handle the child. We are not needed anymore. Or the judge might say, these access centers are really backed up. Can you guys find a third party to supervise the visits? This is a little bit more controversial because, of course, the husband doesn't like somebody on the wife's side. The wife doesn't like somebody on the husband's side. So it's hard to find a third party. However, it is more common right now because the supervised access centers are very busy. So at the case conference, the judge is going to give their opinion, like I said. After that, during the same case conference, the judge might say, can you step outside? Everyone step outside. See if you can come to a resolution. So if there is an option to say, okay, yes, I agree, or I don't agree, if you agree, then the judge will draft up what's called minutes of settlement or a consent, and they'll make it a court order at the time. So there'll be an actual schedule of when each parent should get the child. Now, in the event that people don't agree, so the husband and wife don't agree on this particular schedule or what the judge has said, the judge will then move to the next case conference and they'll try again pretty much. So you'll see 2 or 3 case conferences, and then they'll move to a settlement conference. So at each case conference, they're hoping to narrow down the issues that happen, but if you can't, they'll just keep moving along the court process. So the next one after that is a settlement conference. At the settlement conference, the judge has a little more authority to make decisions, but again, they really try to get everyone to just come to a resolution. In between all of this, you'll see motions. Motions are where the judge can give an actual order. So in a motion, people would submit materials to say, hey, this is the evidence that in this example, dad has abused me and in front of the child on a number of occasions. This is not related to the criminal process because the criminal process would be separate. But the motion is going to give evidence of saying dad doesn't show up, dad's yelling at the child, I don't think it's safe. Dad's going to give his affidavit as well, or his take on everything that's happened in his court materials. And then the judge is going to make a decision. The judge is going to say, yeah, I agree with mom, or I agree with dad, or here's what my decision is going to be. And you have to follow that court order. Versus the case conference, the judge is just letting everyone decide based on his or her opinion. Now, the other option of an application is an urgent motion. When would you bring an application versus an urgent motion? An urgent motion is when something is actually pressing, and it's usually a safety concern. We do bring other urgent motions for travel, but in this context, an urgent motion would be brought for safety issues. So in a case that I've had, there was dad threatened to kill mom, and then mom found a gun in the car. So that would be urgent because there is a situation where we can't wait for a case conference date that might be months later. This needs to be heard right away, and the judge needs to make an opinion right away. So the judge will actually make a decision on that court date, usually get it within a few days or the week after, on what should happen with the parenting schedule. And after the urgent motion, then they'll move back into the regular process of a case conference or settlement conference. So what would a schedule look like? Some schedules, I'm just going to give examples of schedules for people to look at. And I'm marking off pink and blue just for each person. It doesn't matter who it is. And the schedule, it can be anything that works for your parenting dynamic. Everyone has different work shifts. Everyone has different lifestyles. And you have to make what works for you. Otherwise, the judge is going to give some options at a case conference, and everyone just has to pick what you need to pick. So in this one, for example, people can alternate weeks. So I'm just going to back up a bit. There's decision making, which used to be called custody, and there's parenting time. Decision making, often people say, oh, I want sole custody. Custody or decision making is the actual making of the decisions. What school should the child go to? What doctor? What religion? Actual decisions like that, or medical decisions. Parenting time is the access. So when the child is going to be seen, residency is where the child is going to be living. So this schedule here is focusing on parenting time. Decision making, the court will decide what's best for the child. In some cases where I see sole decision making, it's because mom and dad can't get along, or maybe mom's abusive or dad's abusive in the text messages, and they can't make a decision together. Or say mom says, hey, I want to attend this, I want to enroll the child into this school, and dad says, no, I don't care. I'm just very combative. They can't get along and co-parent. So the judge will then usually make a sole decision, an order for sole decision making, or they might do joint, which is both parents need to figure it out together. And then they have a backup plan if they can't figure it out together. And then there's parallel parenting. You don't see this too often, but it's, for example, mom makes the decisions about the doctor, dad picks the religion, mom picks the school, dad picks something else. So they'll kind of align it like that, so there's no crossover. In the case where someone's being charged, this is where the judge will decide whether or not decision-making should go to mom temporarily in the case of if dad's the abuser, or they might say, leave it as joint for now, and we'll decide the decision-making later on in the court process. Sometimes the family courts will wait for the criminal process to unravel so they can know exactly how to make a final order on the parenting time and parenting schedule, but not always the case. So again, in this example, we do alternate weeks. They exchange on the Friday after school is what this example is. And this one, midweek visits. So sometimes you'll have the full week on, week off. So each person has a week, but then you might want to do a midweek visit. And this is in cases where it's important to consider the age of the child, and I'll go into more detail about that type of consideration. You can also see a schedule where it's 2 days, 2 days, 3 days, and then it rotates again. That way, each person has a weekend every other weekend, but there's also a shorter period of time that you go without seeing the children. And then you'll have some people do a 3-4-4 schedule. So this is also a similar schedule, but then depending on the day you start, you might not get any weekends. 2-5-5-2, this is a very common one. So you'll have 2 days, so that way everyone gets every other weekend. And these are all 50-50 schedules. Some people do every other weekend. So like say the child resides with mom primarily and then dad has every other weekend. Sometimes you'll see a midweek visit as well. And these are some considerations. So the first link right there has different parenting plans offered by the federal government. It's actually a really great site because it shows considerations you might think of. Another thing and a really big thing to think about is status quo of parenting time. When you have parenting time and you've had it for a long period of time, so for example, if mom and dad are separated and because of the physical abuse and the police involvement, and mom has the children primarily, and then dad has the kids only every other weekend because that's what they agreed to, the longer this schedule stays, it's called status quo. And what'll happen is if you go to court after, say dad goes to court afterwards and says, hey, I want more parenting time, the judge is going to ask, okay, what is the material change? Now, in the case of the bail conditions, the judge will consider that, okay, there are no more bail conditions. Should we increase parenting time more for dad? But in another situation, the judge might say, hey, it's working for the child. Why would we bother changing it? The focus is the best interest of the child for any of this along the way. While the criminal process is to protect mom and to, I guess, have ramifications for dad's actions, in the family court process, the sole, not the sole, but the predominant focus is what is in the best interest of the child. So is it important for the child to see both parents? Is it safe for the child to see both parents? Should we change this parenting schedule? Is it going to throw the child off their development and their growing? It's really important for children to feel comfortable anytime there's a transition. Already a separation is very difficult for children to adjust. They do, they're resilient, but the courts want to make sure that the children adjust in a progressive way so that they're comfortable. Ages and development. It's important for them to see the other parent more frequency over duration. So it's better to see that for the child to see the other parent maybe 3 times a week for an hour or 2 hours versus 5 hours on a Saturday, every Saturday, because they do forget at such a small age, and it's important for them to be familiar with each parent. Again, I'm going to say that this is a consideration, not mandatory because of the circumstances of the physical abuse and the family court process, but this is a consideration people think of. Even outside of the context of domestic violence, this is a consideration. The development of the child. How is the child developing? Is the child okay with this transition? Is the child need something more educational or courses or special needs? And is this parenting schedule going to conflict with that? So sometimes a therapist will advise that, I think the child should see the other parent this many times or not at all. So it's in the best interest of the child. Safety. So it's important to feel comfortable for both parents to feel comfortable about the safety of the child. Now, when you have the parenting schedules, and I showed the example of the 1 week with each parent, some people want to know where the child is. Not some people. Everyone wants to know where their child is. They want to know, okay, is the child at this person's residence? Are they at a cottage? They want to know. So it is important that the child's location is exchanged by both parents. In the case of the bail conditions, usually people will just tell the third party to say, hey, I'm going to be keeping the child at my mom's house, or we're going to stay at a friend's house, wherever it is. But it's important that both parties know where the child is. It's also important to keep in touch with the child. So especially when they're smaller, you might want to do a video call. Some people have conditions in there where they're going to video call the child every day, after dinner. Other people say that they're just going to do it every other day. Depending on the circumstances or how practical it is, then you'll have that condition or term about keeping in contact with the child. Now, the reality is, when children are really small, they're not going to sit there for a video call. So I often see times where parents complain, oh, the dad or the mom didn't let the kids stay on the video call long enough. It's not practical. If they're two, they're going to be running around everywhere. So it's just important that the child sees the consistency of a video call every Tuesday, every Thursday, around dinner time. They don't have an exact sense of time, but they have an idea of when they're going to expect to see the other parent or talk to them. And of course, there's no one size fits all. These are just general ideas of how cases go, but it's so important to remember that this isn't the exact scenario for each person. So you need to do what fits best for you. And just advise, I know some of you are experiencing the domestic violence. Some of you are service providers. Just know that everyone is doing their best. Mom and dad are doing their best. If you are a survivor of domestic violence, you are giving your best and you're doing the best you can with circumstances. There's no right or wrong way to handle this because it's so difficult to know what to do. Another consideration, again, like I said before, contact with the other parent, whether or not it's good for the child. What does each parent need to feel comfortable with the schedule? So sometimes I get clients say, oh, well, I want dad to, or they might say, like mom will say, oh, dad doesn't know how to feed the child, or dad doesn't know what the child needs to wear, what size clothes they wear. It's very common because oftentimes in parenting situations, one parent just kind of takes the lead. So what is important is to know, okay, what can dad do to make mom feel comfortable? Does dad need to text mom, if the bail conditions are not applicable, or through the third party to say the child is wearing size 2? Does that dad need to say, oh, this is what the child ate, this is what time the child went to the washroom, especially if they're smaller? I see people complain, oh, we're trying to potty train and dad didn't do that. Okay, so how do we address those needs instead of just saying no? Transitions. Like I said, when you're doing these schedules, they don't necessarily have to be perfect right off the bat. We can do situations where it's dad maybe has a few hours on Saturday, a few hours on Sunday, and then we increase it gradually. Like I said before, it's in the best interest of the child to progressively increase the parenting time if that's the avenue we're going to. If you don't think, or if the wife doesn't think that the parenting schedule increasing is good for the child, that's also okay. That's a situation where you present it to the judge, and then the judge will say yes or no, it's good or not. And then attending the court to finalize the parenting plan. So sometimes people come up with parenting plans, especially, like I said before, in the case of the bail conditions. They have the parenting plan just between the third party. But sometimes people do attend family court, to finalize the parenting plan, so it's an actual court order. I will go over court orders. They are not a guarantee of parenting time to be followed. So if your parenting schedule in a court order says dad gets the child every other weekend and then dad's not showing up, there's no real way to enforce it. It's not like child support where we have the family responsibility office and then they can collect the money from like dad's paycheck or whatever the case is. But one thing that people do put inside the terms sometimes is if dad doesn't show up 3 weekends in a row or 2 weekends in a row, then he loses out on parenting time for the next 2 weekends. And it's not so to punish the child, it's to ensure consistency and to deter dad from not showing up. And again, this is just the circumstance of the example I'm giving, but it could be for anyone. Here are some family law resources. So we have Legal Aid Ontario, Ontario Women's Justice Network, FLU. I know Andrea had mentioned that before. There are also some French services as well, Femmes Ontariennes, family court support workers, mandatory information sessions, family law information centers. The family law information centers are actually in the courthouse. Majority of them are still there. Some of them closed down after COVID, but majority of them are still there. So what they do is offer free legal advice, and they help you fill out the forms. You might get less people being able to give the legal advice, and it might just be assistance with filling out some forms. For the mandatory information program, this is when you actually have a court case going. It's mandatory to show up for these information sessions because they provide you with information and resources and give you a heads up on how the family court process is going to go and what to expect. Steps to Justice, they actually give you a great outline of everything. Family Responsibility Office, like I had mentioned before, they enforce child support. The Assaulted Women's Helpline, Ontario Coalition of Rape Crisis Centers, Network of Sexual Assault, Victim Services Directory. And you'll see the other location or the other organizations that can provide help. Law Society of Ontario referral system. You can do a free, if you get a referral, they do offer 30 minutes for free for the lawyer that they connect you with. JusticeNet, you'll have reduced lawyer fees, community legal clinics. You'll see other organizations here. The Ministry of Attorney General. I will say the Justice Canada website has a lot of information and they've done a really great job.
Thank you so much, Athena. Thank you so much for speaking about the safety of children, because this is a very difficult topic when we're talking about family violence, domestic violence, gender-based violence, whatever term we use. It's always very difficult, particularly when children are involved, particularly when we have to think about parenting arrangements for children after the relationship has broken down because of domestic violence or family violence. So thank you so much for walking us through all the information that you did to think about the safety, think about the parent's safety, about the child's safety, and about the court processes that are involved and how we can use those court processes to continue to keep families safe. Thank you again so much, Athena, for this very, very good presentation this afternoon. Thank you everyone for being here. We really, really enjoy these sorts of presentations and providing this information to you. And have a good afternoon, everyone, and take care and thank you. Goodbye.
Thank you so much.